Committee on Health, Employment, Labor, and Pensions will come to order. I note that a quorum is present. Without objection, the chair is authorized to call a recess at any time. Today's hearing will examine the ways in which unions put politics over people through the lens of rampant union anti-Semitism. Unfortunately, the politicization of unions is not new. The National Institute for Labor Relations Research estimates that unions spent about $25 billion in political donations during the 2022 election cycle, or far more than the roughly $2 billion they report as political activities. In the 2020 presidential campaign, President Biden received $27.5 million in direct donations from labor organizations, while President Trump received less than $360,000. While the working class seems to be moving in favor of the GOP in the upcoming election cycle, it's clear that union bosses sold out to the left long ago. Additionally, the response by union leaders to the October 7 Hamas terrorist attacks on Israel have exposed yet another way that unions are beholden to the radical left instead of to the workers they claim to represent. Rather than focus on their stated purpose of negotiating better workplace conditions for workers, unions choose to spend time and money advancing their divisive and anti-American political agenda. Take, for example, the Association of Legal Aid Attorneys, or ALAA. The ALAA represents more than 2,700 public interest lawyers in the New York metro area. And on December 19, 2023, it passed a highly controversial resolution calling for a ceasefire in Gaza. The resolution's inflammatory rhetoric, such as calling Israel an apartheid state, alienated many members and caused nearly 35% of the membership to vote against it. The New York Post has further exposed more details of offensive and harmful anti-Semitism that is rampant throughout LAAA communications. Some of the union members sued the union, but shockingly, the union members who filed the lawsuit were charged with, quote, conduct unbecoming of a union member. Under the UAW Constitution, they were charged under the UAW Constitution, and they're now facing trial with a penalty of expulsion from the union. In other words, the union members shelling out roughly $120 a month to be part of the union will now be put on trial by the same organization intended to protect and represent them, simply for standing up for what they believe. One of the plaintiffs argued, I shouldn't have to financially support an organization that adopts anti-Semitic resolutions, sides with terrorist organizations, and advocates for the destruction of Israel in order to be a public defender in New York. I couldn't agree more. Union members have rights under the Labor Management Reporting and Disclosure Act and the Supreme Court's Beck decision to speak out against their unions and to cease paying union dues for political activities they disagree with. Unfortunately, unions have an incentive to keep their members ignorant of their rights. They often make little effort to inform them of these rights. And as Jewish workers have recently experienced, current federal labor law and Supreme Court precedent fail to adequately protect individual employees' right to refrain from union activity. The ALAA, along with other organizations like the MIT Graduate Student Union, demonstrates how unions neglect their members to pursue left-wing activism at all costs. Today, we're providing a platform for those who are not truly represented by the unions they pay dues to. We will discuss how the law protects their political and religious convictions and how further protections could be provided. Perhaps not everyone here and on the panel agrees on the appropriate role of unions in society, but I hope we can all agree that, if anything, they should advocate on behalf of the workplace interests of workers rather than pursuing a radical political agenda that alienates their members. With that, I yield to the ranking member for his opening statement.
Thank you, Mr. Chairman. I want to start by making clear that I condemn anti-Semitism and all forms of hate, whether it be in the classroom, in the workplace, or anywhere else. As members of Congress and citizens, we have a responsibility to stand up against all forms of hate, regardless of the source of the political party or the political party. And I agree with the chairman that we should do more to combat anti-Semitism. No one should be threatened, harassed, or attacked because of who they are, who they worship, or what they stand for. I look forward to the witnesses' testimonies, but we should avoid the broad brush, stereotypical attacks on workers' ability to organize and collectively bargain that have characterized the subcommittee's 6 prior anti-labor hearings. And based on the title of today's hearing, I fear we'll do it again. And just for the record, corporate interests in the wealthiest in America and income inequality is at its most intense in the history of this country, eclipsing the Gilded Age, is now the advantage of corporations in the top 10%, 16-1. So when we talk about labor contributing to campaigns, they are being buried by corporate interests, particularly after the Supreme Court Citizens United decision. Immigrants, including Jewish immigrants, left their home countries often under duress and sought to build a better life and future for themselves and their families in the United States. Many immigrants opted to organize and join the labor movement because they understood what is still very true today. Unions give workers a voice and have the power to transform their lives through collective action. That means elections, union elections. Throughout history, unions have been pivotal in advancing the conditions and rights of workers, from establishing the 5-day work week to championing minimum wage laws, banning child labor, which is now under attack again, and protecting workers from being maimed and killed at work. Their advocacy, the union advocacy, has been instrumental in building and sustaining America's middle class, which is now under attack. At a time of extreme wealth inequality, workers are increasingly organized because, as they seek the collective and democratic power unions provide them in order to secure higher wages, better benefits, and safer workplaces, union workers enjoy approximately 20% higher wages and are more likely to have access to essential benefits such as health insurance, paid leave, and defined benefit pension plans. These gains not only benefit individual workers and their families, but they also contribute to a more robust economy where prosperity is more broadly shared. Unions also create workplace democracy. Unions are inherently small d democratic institutions. For example, workers need at least majority support in the workplace to form and join a union. Union workers need majority support to authorize a strike. They need majority support to ratify a contract. Workers are their unions, and unions are accountable to their members by a vote. While the fundamental principle of unions is rooted in majority rule, just like any democracy, our nation's laws also protect the rights of individual workers. We are fortunate to have Dr. Anne-Marie Lofaso as one of our witnesses today. The doctor's testimony notes that workers have multiple levels to choose from related to how they want to affiliate with their unions. Union-represented workers have a right to resign from union membership, the right to object to dues beyond representational activities, known as the Beck right, and the right to request a religious accommodation for non-payment of union dues. Those are all rights. Unions are legally required to inform workers of their Beck right and their equal rights and protection under Title I of the Labor Management Reporting and Disclosure Act. While employers are required to inform workers of their right to religious accommodations beyond a basic flyer posted in the workplace, employers have no obligation to directly inform workers of their rights to organize a union or come together with their coworkers to engage in concerted activity regarding the terms and conditions of employment. As we discuss these issues today, let us not forget that the true threat to workers' freedom and rights is not unions, but bad employer, low-road employers, intimidation and retaliation, as well as deficiencies in our labor laws to hold unscrupulous businesses. As I've said many times, it's not responsible businesses, it's a few businesses that bring the whole culture down to us versus them, more money for us and less for them. Not all businesses, just the ones that don't play by the rules, accountable for violations of the law. These include employers holding mandatory coercive captive audience meetings, inadequate penalties for violating workers' rights, and prolonged delays in justice for workers facing retaliation. We must reaffirm our commitment to strengthening workers' protections and advancing legislation such as the PRO Act, Protecting the Right to Organize Act. This landmark legislation would modernize our labor laws for the first time in decades, empowering workers to organize freely and ensuring that employers are held accountable for their actions. Lastly, we have a responsibility to fund the very agencies that enforce workers' rights. We should make sure we are appropriately funding key agencies like the National Labor Relations Board and the EEOC so they can fulfill their vital mission to protect workers. Thank you, Mr. Chairman, and I yield back.
Thank you. Pursuant to Committee Rule 8C, all members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5:00 p.m., 14 days after the date of this hearing, which is July 23rd, 2024. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous materials referenced during the hearing to be submitted for the official hearing record. I will now turn to the introduction of our distinguished witnesses. Our first witness is Ms. Elana Copar, who's a staff attorney employed by the Nassau County Legal Aid Society in Hempstead, New York. Welcome. Our next witness is Mr. William Susman, who's a graduate student at the Massachusetts Institute of Technology, or MIT, in Cambridge, Massachusetts. Welcome, Mr. Susman. Our third witness is Dr. Anne-Marie Lofaso, who is a professor of law at West Virginia University College of Law in Morgantown, West Virginia. Welcome, Dr. Lofaso. And our final witness is Mr. Glenn Tobman, who is a staff attorney with the National Right to Work Legal Defense Foundation, which is located in Springfield, Virginia. Welcome, Mr. Tobman. We thank the witnesses for being here today and look forward to your testimony. Pursuant to the committee rules, I would ask that you limit your oral presentation to a 5-minute summary of your written statement. And I'd like to remind the witnesses to be aware of their responsibility to provide accurate information to this subcommittee. We'll now recognize Ms. Copar for 5 minutes.
Thank you. Good morning, Chairman Good and Ranking Member DeSagne. I'm a criminal defense attorney at Nassau County Legal Aid, and I'm also a member of the UAW Local 2325, the Association of Legal Aid Attorneys, the ALAA. I'm also Jewish, and Zionism, the belief in the right of the Jewish people to self-determination in our ancestral homeland, is as integral to my religious practice as is keeping kosher and observing the Sabbath. Most American Jews share this belief that Zionism is integral to their Jewish faith. After Hamas's bloody attack against Israel on October 7th, the ALAA and its leadership created an anti-Semitic, hostile work environment for its Jewish members for whom the existence of Israel is integral to their Jewish identity and for their non-Jewish allies. On November 14th, the ALAA just gave 3 days' notice of a membership vote on a resolution entitled Resolution Calling for the Ceasefire in Gaza and End to the Israeli Occupation of Palestine. Despite its title, the resolution was not a call for a ceasefire, but for Israel's defeat. The resolution doesn't mention Hamas even once. It dehumanizes the victims of October 7th by not mentioning that Hamas massacred, raped, and mutilated Jews, Israelis, and Americans, and violently abducted men, women, and children. Instead, it's a one-sided, vitriolic attack against the Jewish state using anti-Semitic tropes and language widely understood to be a call for the destruction of Israel. 3 of my colleagues and I from my office believe that this anti-Semitic resolution would interfere with our ethical responsibility to zealously represent our Jewish and Israeli clients free from discrimination. It also added to an already hostile anti-Semitic environment in the union. So we sought and were granted in state court a temporary restraining order halting the vote. After the case was removed to federal court, the TRO was dissolved, the resolution passed, with just over half of members voting at all, and 1/3 of those voted no. Immediately after filing the TRO, the union retaliated and filed internal charges to expel us. They accused us of conduct unbecoming to a union member, even though we have a legal right to oppose the union's anti-Semitism. We appealed to the UAW International Executive Board. It denied our appeal without even considering our legal arguments. If we hadn't filed an immediate appeal of that decision to the UAW's Public Review Board, The union was going to start jury selection in our expulsion trial tonight. We have now filed our own charges against the union with the EEOC and brought a lawsuit in federal court for violating our labor rights and unlawful discriminatory retaliation. After the TRO, the union's anti-Semitism against us intensified. In Gaggle, an email listserv for members, and in member-wide Zoom meetings, we were called fascist, genociders, fascist colonizers, Zionist ghouls. We were told to go kill ourselves. Members advocated kicking Zionists out of the union and outrightly called for the elimination of Israel. One member stated that the union has a duty to stand up and call for an end to Israel, and signed their email with the Nazi reference, goose stepping outside. When Jewish Zionist members introduced a resolution to free the hostages, the immediate response on Gaggle was LMAO, laughing my ass off. Another responded that this resolution confirmed that Zionist union members were not comrades, but fascist colonizers. At the joint council meeting, the resolution's presenters were called disgusting and effed up, and they were called to mute them. Members wanted to kick out a Jewish member from the meeting for expressing typical Zionist lies. The union overwhelmingly voted down the resolution calling to free the hostages. ALAA President Lisa Oda and leadership were at that meeting, and they did nothing to stop the attacks or tamp down the bullying and vitriol. The next day, a paid ALAA staffer emailed the membership characterizing the hostage release resolution as a small Zionist minority attempting to disrupt the ALAA. He also blamed the Zionists for collaborating with this congressional committee and attempting to weaken the union. I'm not here to weaken the union, but to strengthen it. The union is tearing itself apart. Union leadership has a duty to protect its members from bias and discrimination, not foster attacks against its Jewish and non-Jewish Zionist members. This is not how a union should act, and we should not be forced to support the discriminatory actions. Thank you so much for inviting me. It's been an honor and a privilege.
Thank you, Mr. Susman. You're recognized for 5 minutes.
There we go. Chairman Good, Ranking Member DeSaulnier, and members of the subcommittee. My name is William A. Susman. I am a doctoral student in computer science at the Massachusetts Institute of Technology, and this past year I served as president of MIT graduate Hillel. Last December, this committee heard MIT's president testify that calling for the genocide of Jews can be anti-Semitic depending on the context. Allow me to share some of that context. According to the Anti-Defamation League, the Boycott, Divestment, and Sanctions Movement, or BDS, is an international campaign aimed at delegitimizing and pressuring Israel through the diplomatic, financial, professional, academic, and cultural isolation of Israel, Israeli individuals, Israeli institutions, and increasingly, Jews who support Israel's right to exist. The MIT Graduate Student Union, known as the GSU, has engaged in BDS since its inception. It's one of the reasons they chose to affiliate with the United Electrical Workers, or UE, which endorses the BDS movement and urges the union at all levels to become engaged in BDS. In 2022, a plurality of MIT graduate students voted to install this union as our exclusive bargaining agent, and in September 2023, MIT capitulated to its demand for a contract with mandatory dues. Then came October 7th. According to the American Jewish Committee, Hamas terrorists waged the deadliest attack on Jews since the Holocaust, slaughtering babies, raping women, burning whole families alive, and taking hundreds of innocents hostage. The blood had not yet dried when my colleagues at MIT declared, "Victory is ours." The full-time GSU staff organizer told NBC 10 Boston, "Those who rebel against oppression cannot be blamed for rebelling against that oppression." In November, my union representative joined anti-Israel protesters who were occupying a building, and when threatened with suspensions, the GSU backed the protesters. Meanwhile, the GSU illegally threatened to terminate anyone who refused to pay for their so-called activism. I filed a charge against the union with the National Labor Relations Board, which agreed that the GSU had violated our back rights. However, the NLRB refused to require training of union agents who continue to break the law. In January, when MIT brought disciplinary charges against 2 graduate student protesters, the GSU blamed external pressure from billionaire donors and right-wing politicians and organized another protest, this time in front of the Discrimination and Harassment Office. One picket sign read, "Anti-Zionism does not equal anti-Semitism." In April, the GSU pushed through a ceasefire resolution that does not mention peace, hostages, or Hamas. And in May, the GSU vice president was arrested at yet another protest. She was banned from campus, but remains on paid union leave. As I wrote in the Wall Street Journal, Jewish graduate students are a minority at MIT. We can't remove the GSU or disabuse it of its anti-Semitism. But we also can't support an organization that actively works toward the eradication of the Jewish homeland where I have family living now. That is why many of us asked for a religious accommodation that would divert our compulsory dues from the UE to a charity. The union denied my request, telling me in a letter that no principles, teachings, or tenets of Judaism prohibit membership in or the payment of dues or fees to a labor union, that one of UE's founders was Jewish, and that opposition to BDS isn't a position I hold for religious reasons. In other words, UE thinks it understands my faith better than I do. With the help of the National Right to Work Legal Defense Foundation, I joined 4 other Jewish graduate students in filing discrimination charges against the union with the Equal Employment Opportunity Commission. In response, the GSU chanted shame against us, calling our lawyers well-financed. They forgot to mention our horns. Facing potential charges of its own, MIT began approving religious accommodations, and the union followed suit. But UE represents graduate students at a dozen other universities, and it should not take 5 discrimination charges to exercise our freedom of religion and association. This Congress should pass the National Right to Work Act so that unions have to earn their dues and think twice before discriminating against minorities. As a lifelong Democrat, I would like to conclude with a warning for my fellow party members. A major union president who voted for FDR 4 times would later in life say, "I didn't leave the Democratic Party left me." That union president was Ronald Reagan. If the Democratic Party leaves the Jews, we will have no choice but to leave the party. Ironically, this incentive structure is precisely what's missing from unions. Thank you for the invitation to testify today, and I look forward to answering your questions.
Thank you, sir. Dr. Lofaso, you're recognized for 5 minutes.
Good morning, Chairman Good, Ranking Member DeSagne, and distinguished members of the subcommittee. I'm Anne-Marie Lofaso, a labor law professor at West Virginia University and a former NLRB attorney. Thank you for inviting me to testify regarding employees' rights to know their labor rights. There's been renewed interest in unions among workers with a record high support of 71%. Workers want unions and should know all of their rights, including how labor law provides recourse to protect against anti-Semitism and other forms of hate. Let's start with what the law already requires of unions. The law already requires unions to inform members of their Title I and their BEC rights. The law also requires a union to represent fairly and non-discriminatorily all employees in the bargaining unit, including non-members who pay no dues. Religious objectors have at least 6 avenues of recourse if their union acts contrary to their religious beliefs. First, a religious objector, like any employee, can refuse to join a union and can resign from a union at any time. Second, under Section 19, that expressly allows religious objectors to refuse to pay any dues, but may be required to donate to a non-religious, non-labor charity in the same amount they would have paid in dues. Third, a union's refusal to accommodate a religious objector's request to substitute charitable payments for union dues makes a prima facie discrimination case under Title VII, and the law requires employers to post these rights. Fourth, the objector could file unfair labor practice charges or a lawsuit against the union alleging a violation of the union's duty of fair representation, such as a failure to process grievances of Jewish employees. Fifth, if a union or the employer tries to inflame employees' passions by dividing them using religiously inflammatory words during an organizing campaign, any party can file objections to the union, which may result in a rerun election. Sixth, in the public sector, a religious objector may also have constitutional claims against the union. Now let's look at what the law does not require of unions or employers. No one is required to inform workers of any of their NLRA rights other than BEC rights, that is, the right not to join a union. This subcommittee should put its energy in solving the real problem facing workers: employer interference with their right to free association and workers' lack of awareness of the broad spectrum of rights they enjoy under labor laws. Few private sector workers understand that labor law protects them even if a union does not represent them. Employees are protected if they discuss how to improve their working conditions during break times and in non-working areas. Employees cannot be fired for expressing their support for labor legislation or for invoking their Weingarten rights. Workers should be informed of all their labor rights, not only Title I rights, Beck rights, and their right to religious accommodation, but all their rights. A simple fix would require employers to post these rights in the workplace alongside other employment rights posters. Even when workers know their rights, the NLRB is underfunded, making it challenging to conduct union elections and combat unfair labor practices, including union ULPs. Congress should fully fund the board and EEOC to ensure enforcement of all workers' rights, including their Beck rights and their religious accommodation rights. To the extent that compliance with the LMRDA's disclosure requirements is problematic, those problems seem to be on the management side. Congress should fully fund the Department of Labor's OLMS to ensure compliance. Even when workers know their rights, they are often met with employer resistance during an organizing drive or first contract negotiations. Given the Act's weak remedial scheme, some employers prefer to pay lawyers to defend ULP charges, knowing that, even if they lose, the remedy is often a no-cost notice posting. However, the Act is limited to public causes of action, meaning that access to private relief by a court is typically preempted. This is why the passage of the PRO Act is so important. The PRO Act would strengthen the Act's remedies and require the agency to seek injunctive relief to reinstate employees whenever it has reasonable cause to believe that the employee's job termination was unlawful. The PRO Act would create a private cause of action, giving workers access to courts rather than relying on the board's general counsel to enforce their rights. The PRO Act would also make mandatory captive audience speeches unlawful, thereby diminishing the employer's power to interfere with employee free choice. I welcome this subcommittee's support for workers. I ask that the members of this subcommittee better target the problems facing workers so that workers know all their rights and can enforce those rights against all institutions, including the government, business, and labor unions. Thank you.
Thank you. And finally, Mr. Tobman, you're recognized for 5 minutes.
Thank you for the opportunity to appear today. I have been practicing labor and constitutional law for over 42 years at the National Right to Work Legal Defense Foundation in Springfield, Virginia. My clients are individual employees who wish to stand apart from the workplace labor union they did not choose and do not want. For 42 years, I have helped litigate the Foundation's groundbreaking Supreme Court cases like Communications Workers versus Beck and Janus versus AFSCME. These decisions recognized individual employees' constitutional and statutory rights to partially limit their association with labor unions they wanted no part of, but were nevertheless forced to join or fund. Despite these Supreme Court decisions, I must regularly explain to my clients that while they can choose to join any house of worship, any affinity group, or fraternal organization that they want, federal law prevents them from choosing the agent that exclusively represents them in their workplace. And in half the states without right-to-work protections, they must pay union dues or be fired. But since October 7th, those once routine explanations of basic labor law have become dark, sobering, and often heartbreaking conversations about the reality of union anti-Semitism and legalized compulsion in the workplace today. Now my phone is ringing off the hook with calls from unionized Jewish and Israeli graduate students at this nation's elite educational universities. MIT, Columbia, University of Chicago, to name a few, asking me how they can disassociate from the union that is partnering with and often leading groups that organize protests to shut down the campus, destroy property, chant genocidal anti-Semitic slogans, and menace them on campus. Many of these employees are forced to pay dues that go directly to subsidize the union's celebration and support of Hamas's massacres. In case any of you need reminding, Hamas is a medieval death cult on the U.S. government's terror watch lists, not unlike ISIS and Al-Qaeda. Wearing masks at the workplace while chanting "Death to Zionists" from the river to the sea is not benign or legitimate union bargaining activity. My phone is also ringing off the hook from medical residents and interns at some of the nation's finest teaching hospitals, asking the same question as their union is busy poisoning their workplace with hateful and exclusionary anti-Jewish and anti-Israel propaganda. My phone is ringing off the hook from teachers and legal aid lawyers, all of whom wonder how the union they used to support and even champion had suddenly turned away from advocacy for better benefits and toward radical advocacy against Israel's just and moral defensive war, a war that is occurring thousands of miles away from their workplace. Federal labor law has long allowed employees to be trapped by exclusive bargaining agents they never voted for and do not want. But today, Jewish employees find themselves forced under the thumb of exclusive bargaining agents who are loud and ardent supporters of the Hamas death cult. At the National Right to Work, we are redoubling our efforts to help such employees forcibly saddled with anti-Semitic unions. We have filed Beck charges because unions falsely tell employees that they must join and must pay dues, even when the money is spent to support radical campus protesters. And we have filed charges of religious and ethnic discrimination with the EEOC because unions refuse employees' requests for religious accommodations. But despite our best efforts, Title VII and Beck are not nearly strong enough protections. As long as unions can force workers to pay anything to get or keep a job, employees will be denied their full freedom of association, speech, and conscience. The Janus decision was a small step for employee freedom in the public sector. Now is the time for this Congress to pass the National Right to Work Act in the private sector to end the problem of coercive forced unionism and the particular problem of compelling Jewish and other religious employees to fund unions whose views and activities are hateful, threatening, and deeply divisive. What could be more American than that? Thank you, and I look forward to answering your questions.
Thank you, sir. Under Committee Rule 9, we'll now question witnesses under the 5-minute rule. I will wait to ask my questions and therefore recognize Mr. Wilson from South Carolina for 5 minutes.
Thank you very much, Mr. Chairman, and thank you, witnesses, for being here today. And particularly, I'm very grateful, Mr. Tobman, the National Right to Work Committee is truly the champion for workers' rights, promoting freedom since 1955. That's just extraordinary to have such a strong life and so successful. And it's to achieve a majority of the American states to enact right-to-work laws for protecting workers' freedom of choice. In South Carolina, it was instrumental in working with creating 10,000 jobs at the Boeing Aircraft Company with its suppliers to build 787 jetliners several years ago in Charleston, Orangeburg, Aiken, and Lexington. I was grateful to be working with Governor Nikki Haley, U.S. Senators Tim Scott and Lindsey Graham, and Attorney General Alan Wilson with the Right to Work Committee, and you prevailed over the corrupt National Labor Relations Act, and now 10,000 workers, thousands of families are benefiting from what the Right to Work Committee has achieved. The Right to Work Legal Defense Foundation is working with Jewish and Israeli employees to protect their statutory and civil rights in the face of anti-Semitism. Can you discuss these workers' reactions to their unions supporting anti-Semitic and anti-Israel causes despite having a legal duty to protect the interests of all members they represent?
Thank you very much, Congressman Wilson, for that question. As I said in my statement, it is heartbreaking for me as a Jewish American and as a Zionist to have my phone ringing off the hook every single day since October 7th by students, workers, teachers, legal aid lawyers, doctors saying, how do I get out of this? I am surrounded by vicious people attacking me as a Jew, attacking me as a Zionist. I have friends in Israel. I have family in Israel. I have friends who served in the IDF, the most moral army in the world, perhaps second only to the United States Army. And they are attacked in their workplace. So that is the reaction that I am seeing. And unfortunately, I cannot say to all of these people, exercise your constitutional rights to get out, because under the National Labor Relations Act, they cannot get out. They are forced to be part of a bargaining unit and forced to pay dues to a union or be fired. And finally, although we've heard that unions have an obligation to tell people about their rights, in fact, few unions do. And if you look at the exhibits to my statement, you'll see that in Exhibit 5, for example, this is a pamphlet that the union at MIT put out to students. They say, you are required to sign up for either dues or agency fees as a condition of employment. The cost of dues and agency fees is exactly the same. That's a lie. The whole point of Beck is that the cost of reduced dues is different. You don't have to fund these obnoxious, outrageous political actions, but the unions lie and tell people they do.
Well, thank you for the Right to Work Committee for telling the truth. And Mr. Susman, thank you for your courage. Indeed, the Graduate Student Union had an email in December 2023 which condemned MIT administrators for shutting down what they call peaceful protests. What were these peaceful protests?
Thank you, Mr. Wilson. The students would occupy buildings. They would occupy communal spaces on campus that are supposed to be shared. And over time, they would escalate, and I included in my testimony the arrest records of several students, many of whom are graduate students in the union, one of whom is the vice president, who is paid by the union. And many of those arrests were violent. I believe one person is charged with assaulting a 60-year-old disabled person.
And again, thank you for your courage, and I regret, Ms. Copar, I don't have time, but thank you for your courage, and indeed to have the Association of Legal Aid Attorneys to ignore or disregard mass murder and rape. Thank you for the courage to stand up against that, and the Hamas puppets of the regime in Tehran need to be addressed. Thank you very much. I yield back.
Thank you. We'll now recognize Mr. Norcross from New Jersey for 5 minutes.
Thank you. I want to start out by saying we live in the greatest country in the world. We live in a democracy which we have elections, whether they're for members of Congress or for their representatives as their union voices. But I do want to take a moment of personal privilege to thank the chairman. He and I agree on little, if anything, but I do want to thank him for his public service and wish him well in any future endeavors that are coming out. We really, we need more public servants, but we appreciate what you've done and wish you well. Start out by saying we're in due process. I heard stories. What is going on in this country with anti-Semitism is horrific in any form. We heard many of our hearings what is going on college campuses, and I couldn't agree more. But we live in a country that's democracy, and unfortunately, many of those views are something that I personally disagree with, as many of us. But in this country, and to quote our friend from the Institute, Mr. Tobman, we did not choose and we do not want many of our elected officials. Some might even be in this room. And we are forced to fund them, whether it's a union or our government. But the idea or suggestion that because of a few bad actors, which we make no excuses for, are being anti-Semitic and smearing the entire representatives of workers, I think, is no different calling unions anti-Semites. You could call Republicans racist. You call Democrats socialists. But it doesn't make it true. But if we look back in our history, we certainly did have racists that served in this House. But the idea that somehow this is breaking out. I'm sorry, did you say something? You looking to yield time from me, Chairman?
You finished with your time?
No, you were
proceed.
talking. I thought you were wanting me to yield some time.
I thought maybe you were talking about the Southern Democrats and the KKK.
I claim back
thought
my
that's what
time.
you were talking
Thank you.
about.
You're done in more than one way. So the idea of what we're doing each and every day is how democracies work. So my question goes back to whether they have votes on authorizing strikes, ratifying contracts, union leadership, the votes that go on each and every day. This is not a top-down, this is a bottom-up. This is something that we believe in our nation and certainly in the unions. Dr. Lofaso, can you talk to us a little bit more detail what you started to talk about, where those rights of a union member, when it comes to dues, when it comes to the votes on where that union comes together. But at the end of the day, they have a vote, whether they agree with it or they don't, just like we do in this country when we have votes. Could you expand on some of those issues, particularly right-to-work states versus non-right-to-work states?
Okay, so first of all, no worker can be compelled to join a union in any state. In right-to-work states, they also cannot be compelled to pay their dues. I think that we agree on that. In non-right-to-work states or fair share states, the only thing that union-represented employees have to pay are their agency fees, which is, as Mr. Tobman pointed out, they are reduced fees because the Supreme Court has stated very clearly that unions cannot force anyone to pay for their political activities or non-representative activities. So there is a big difference in right-to-work states and not right-to-work states. Also, with respect to a national right-to-work law, there already is a solution for that too, which is to lobby. The states can do that. Every state can do that if they want, and it would have the same effect. West Virginia was one of the most democratic states until recently. It was not right-to-work, and now it is recently right-to-work.
So,
sorry.
No, we understand. So the idea that they do have a choice, they are represented by agency fees, we understand all that. But the idea of having a hearing, one of only maybe a dozen a year, making this your highest priority. I have yet to have, and I live in a very Jewish area, one person come up to me and talk to me about unions being anti-Semitic. But this goes to the case of what we're dealing here.
Gentleman's
Thank
time
you
has
for
expired.
giving me
Thank you,
those
sir.
additional 10 seconds,
Thank you, sir.
Mr.
All
Chairman.
right, we'll
I really
now
appreciate it.
recognize
You
Mr.
have a good
Wahlberg
day.
from Michigan again for 5 minutes. Thank you.
I thank the chair for holding the hearing today. And again, I would state it's not anti-union. We're anti-union abuse of their power and violation even of the law. That's what our concern is with today and has been. About a month ago, this subcommittee held a hearing where I highlighted the Wall Street Courageous Wall Street Journal opinion piece written by Mr. Susman. And so I'm pleased to have Mr. Susman here today to again be courageous and stand and hopefully produce other young people that are willing to stand, not for Republican, not for Democrat ideals, but for American ideals and decency that ought to go on with this country. I thank the committee for its work in highlighting this important issue. Mr. Susman, your written testimony notes that the Graduate Student Union threatened to terminate anyone who refused to pay for their so-called activism. In all reality, that would virtually expel you from MIT, not for academic problems, not for disciplinary problems, but the fact that you weren't willing to be represented by an entity that spoke against you and your beliefs. You filed a charge against the GSU with the National Labor Relations Board regarding the union violating your BEC rights, which allow workers to opt out of paying the portion of union dues that pays for political activity. You're following the law. My question is, while the NLRB agreed that your rights had been violated, do you believe it adequately addressed the illegal union activity?
I do not. They required the union to send out a PDF stating our rights, and that was basically the last we heard of it. They continued doing the same exact tactics that I charged them with last November, but the NLRB closed the case anyway, and they refused to require training of the union agents so that they wouldn't make the same mistake.
And still haven't. In your written testimony, Mr. Susman, you detail numerous examples of the GSU and its paid staff engaging in extreme anti-Israel and anti-American, we must not forget that, anti-American activity. For example, 2 days after October 7th attack on Israel, a paid GSU organizer told reporters, and I quote, "Those who rebel against oppression cannot be blamed for rebelling against that repression." Despite the union that represents you engaging in behavior that is inconsistent with your beliefs, you have no choice but to associate with it or to leave MIT. Question: do you think current federal labor law needs to be reformed to allow workers who have moral objections to a union's political stances to dissociate completely from the union that represents them?
Absolutely, yes. I've tried to use the law as it exists, and at every turn, the law has failed me.
Yeah. In some ways, it's still absurd to think we're talking about a union of students. Very much different than what union, Steelworkers Union I was a member of at one time, and others had in mind. Mr. Susman, an attachment to your written testimony shows a December 2023 email from the Graduate Student Union at MIT. The email condemned MIT administrators for shutting down what it calls a peaceful anti-Israel protest and highlighted the importance of First Amendment rights. He responded to my colleague, Mr. Wilson, about some of those activities. Do you believe that the GSU has respected the First Amendment rights of the Jewish graduate students they represent?
No, they have not respected our rights, specifically speech, religion, and association.
In fact, they've stepped on them. They've pushed them down, pushed them back, tried to discourage any dissent from that, and still expected you to pay up, while people that should be representing you fight against you, your belief, your nationality, your religion, and your American ideals as well. Mr. Susman, I would encourage you to continue standing firm. I believe others are watching. I believe there's others that will gain strength and courage themselves to follow you. It won't be easy, as Mr. Tobman has identified in his efforts for 40 years, but it must be done for America as well as freedom and First Amendment liberties, and I yield back.
Thank you, and we'll now recognize Ms. Jayapal from Washington for 5 minutes.
Thank you, Mr. Chairman. I have been appalled at the rising level of hate crimes against the Jewish community that followed Hamas's terrorist attack on Israel on October 7th, and I believe it is absolutely critical that we speak out against anti-Semitism, that we recognize the severity, and we condemn and confront it authentically. President Biden's national strategy to counter anti-Semitism importantly recognizes that, quote, protecting the Jewish community from anti-Semitism is essential to our broader fight against all forms of hate, bigotry, and bias, and to our broader vision of a thriving, inclusive, and diverse democracy. I am also very proud to come from Washington State, which is the third most unionized state in the country. And because of that, we have the highest minimum wage of any state in the country. We have an incredible paid leave policy in our state. We have the third best environment for small businesses of any state in the country. Unions have been an absolute incredible partner to achieving justice and equality for all communities. Unions have long recognized the interconnectedness of all our issues and that conditions on the job are impacted by conditions in the world. From the civil rights movement to marriage equality and protections for undocumented workers, unions have been on the forefront of social and socioeconomic progress. UAW Local 2325, which is under scrutiny by my Republican colleagues, has a history of activism opposing the Vietnam War, apartheid in South Africa, the Iraq War, and instances of police brutality. And I'm disappointed that my Republican colleagues are convening this hearing to question a union exercising its First Amendment rights, especially at a time when there are real issues of anti-Semitism that we all need to address. And unionized workers are standing up in record numbers to secure contracts that guarantee that they receive their fair share of corporate profits through dramatically raised wages and increased benefits. So it seems to me that this hearing is really about criticizing unions, which has always been a Republican position to try to undermine unions, instead of the real issues that we should be talking about. We've heard a lot of attacks today directed at UAW Local 2325 for adopting a ceasefire resolution. Dr. Lofaso, can you share the process behind how this resolution was adopted?
I can share the process, how it is likely to be adopted, because I do not actually have any firsthand knowledge of the UAW local. What normally is done is that unions have bylaws and constitution that they're ratified by majority vote, so it's a democratic process, and then then those are the rules by which they have to live by. After that, a resolution like this would have to go by their rules, and if they did, they would be democratic. Now, if sometimes democracies fail us, and so there are dissenters. We have 2 dissenters here. They're important. Their voices are important because the law in this country has recognized that we don't need to protect popular speech. We do. But we don't need to because it's popular. We need to protect unpopular speech. So it's very important what they've done. And I think they prove my point, which is they had recourse. And to the extent they didn't feel that they had recourse, which I can appreciate, like in Mr. Susman's case, I think part of that is the underfunding of the NLRB.
Yes.
Because sorry.
I agree with you there. I have a couple more questions.
Yeah,
Sorry, but I want to point out some important things you said. It's a democratic process, right? Constitution,
Yes.
bylaws, democratic vote. It was adopted through a vote, and has always been the case. I think we have to understand that labor unions are an extension of democracy in the workplace.
Yes.
And that is the way that they're structured. Can you discuss, just briefly, because I don't have much time, how workers are impacted, how it impacts their ability to organize when Congress issues subpoenas over votes that the union as a democratic institution has taken as the Republican majority is doing?
Well, anytime Congress issues a subpoena, it's going to have effect of repressing that institution because Congress is a scary body, right? It's the government, it's compelling you to come to it. So that would be something that would repress that democratic institution and something that is odd for an elected body to do.
Extremely odd and extremely undemocratic. Thank you so much. I yield back, Mr. Chairman.
Thank you. We'll now recognize Mr. Allen from Georgia for 5 minutes.
Thank you, Mr. Chairman, and I want to thank the witnesses for your courage and your honest testimony this morning. You know, the battle rages on in the country about, you know, like who are we? And what are the values that we enjoy in our workplace, in the greatest workforce, the greatest military on the face of the earth? And what are those values based on? For example, this hearing is in the House of Representatives. In our chamber, we have above the flag, etched in stone, "In God We Trust." In fact, it's on our currency. Is that God the God of Abraham, Isaac, and Jacob? Genesis 12:3 is very clear about the circumstances that we're dealing with right now. We have the full face of Moses looking down on that body who gave us the law, which is the basis of our values that we enjoy. Most of our leaders ask for God to bless America. Well, that's covered very well in Genesis 12:3. God says, if you bless Israel, I will bless you. And then he says, all the nations would be blessed through Israel. In my state of Georgia, we are a right-to-work state. There are 27 states. Lots of states are doing well, but Georgia has had the distinct honor to being the best state to do business in for the last 10 years in a row. Georgia has great companies who value their employees, both union and non-union. It is damaging to these great companies, those who are non-union, to say that they're bad actors because they're not union. Because, folks, we have a modern workforce. And based on the values I just described, the scriptures are very clear on how you deal with your workforce, the folks that work for you. They're very clear. And I don't have time to line all that out today because I got a lot of questions to ask. But the bottom line is, we've got to decide where we want to be as a nation. Right now, we're in crisis because we are a lawless land. And that's why we're having lots of these discussions, which are very difficult for a lot of the citizens of this country. Mr. Tobman, under Communication Workers of America versus Beck, the U.S. Supreme Court determined that workers represented by a union can choose to opt out of paying the portion of dues that funds union political activity. In your experience, do labor unions respect workers' decisions to exercise their Beck rights?
Thank you, and the answer is absolutely not. It demonstrated in part by what we have in this case at MIT. It's in the exhibits to my testimony. The union tells people you must pay full dues or you must pay an equal amount of agency fees. Equal, which is false. And that's what they tell these graduate students.
Are workers well informed of these rights?
Not in the least.
Can you discuss some ways that labor unions have used members' dues to support anti-Semitic and anti-Israel activities?
It's all in the attachments to my statement. The unions, instead of trying to protect Jewish students from these pro-Hamas rioters, when the schools finally get up the nerve to suspend or expel the pro-Hamas rioters, the unions file lawsuits and unfair labor practice charges against the schools to stop them from suspending the pro-Hamas rioters.
Ms. Copar, I got 30 seconds. In your opinion, have ALAA members stop participating in unions because of the rancor leading up to the passage of the resolution calling for the ceasefire?
Yes, definitely. I mean, many of us have been stifled. We aren't able to be as vocal as we can. There, as I mentioned on Gaggle, Gaggle is this email listserv that members are able to post their emails. But Zionist members are constantly being bullied on it. It's not a safe space for any of us. I will never go on Gaggle because I know that I'm going to be ridiculed and threatened. So I will never. My voice is stifled. And every time we go on a joint council meeting, we are also, a joint council meeting is a membership-wide meeting. Again, our voices are stifled. We are called despicable names. We are bullied constantly in front of leadership. It's not just a few bad actors.
That's why the leaders of this nation have got to decide to protect our citizens. And Mr. Susman, I have more questions for you. I'll submit those for the record. Mr. Chairman, I apologize. I ran over my time.
My apologies to everybody for letting you go that long. So thank you, Mr. Allen. Recognize Mr. Courtney from Connecticut. Now recognize Ms. Manning from North Carolina for 5 minutes.
Thank you, Mr. Chair and Ranking Member, and I want to thank our witnesses for sharing your stories. I am deeply disturbed about what you have been through. And I want to be very clear that anti-Semitism has no place in any workplace, in any school, in any union, or any other facet of American life. It is simply unacceptable. And I want to emphasize that President Biden's national strategy to counter anti-Semitism actually requires the Department of Labor to disseminate resources to unions on recognizing anti-Semitism and the importance of combating this hate in relation to workers' rights. The national strategy, which I have put into my Combating Anti-Semitism Act, would offer real, tangible solutions to combat anti-Semitism in our country. And that is why I am asking once again that we mark up my legislation and support the President's proposed strategy to take serious action to fight against the uptick of anti-Semitism and despicable hatred in our communities. And both of these could also be addressed by increasing funding to the EEOC and the OCR. With that said, Ms. Lofaso, you highlighted the legal duty of unions to fair representation and non-discrimination. And discrimination based on religious views in union organizations is illegal according to federal law. Is that correct? And Ms. Copar has highlighted her case in which 4 members of the Association of Legal Aid Attorneys filed charges to expel her from the union. These charges came after Ms. Copar secured a temporary restraining order to stop a union-wide vote from taking place on an anti-Israel, anti-Semitic resolution. Do these filings to expel Ms. Copar constitute retaliation in your opinion?
Under those facts as you gave them, that sounds like retaliation to me.
Thank you. Ms. Copar, I want to turn to you. I want to thank you for bravely coming here today to discuss your appalling experience in facing anti-Semitism within your union, your workplace. And you consider yourself generally a pro-union person, is that correct?
That's very much correct.
And would you agree that unions are instrumental in fighting for higher wages, better working conditions, and inclusivity in the workplace? Would you agree with that?
Yes, I would.
And like the ALAA, other unions, including the NEA, have weighed in on this issue. And does engaging in divisive political resolutions help support these goals, the goals of a union?
No, it does not.
Thank you. As part of your effort to strengthen the union and protect yourself from anti-Semitism, you mentioned that you filed charges with the Equal Employment Opportunity Commission. Is that correct?
Yes, that is.
And in your experience, would giving more funding to the EEOC help them provide the action that they need to help resolve claims like yours?
I believe so, because I know that we've been waiting for a while to receive a response from the EEOC. So more funding would then lead to a quicker response.
Do you believe that legislation that increases education about workplace anti-Semitism and combating anti-Jewish hatred for union members would help address this problem?
I think so, yes.
As you've emphasized, the EEOC is a much-needed tool for union members, and all Americans who have experienced discrimination in any form. And we've had other hearings on this topic, and it has become clear that there are also awareness issues, that workers simply don't know that they can turn to the EEOC, or students don't know that they can turn to the OCR when they experience Jewish anti-Semitism or anti-Jewish hatred. So more funding would be appropriate. Let me just close by saying that if my Republican colleagues are serious about combating anti-Semitism in the workplace or on college campuses, they need to do more than holding hearings. They need to stop presenting us with budgets that drastically cut the funding for the EEOC or the OCR, and they should bring my Countering Anti-Semitism Act to the House floor for a vote so that we can give the government the tools they need to fight this rising form of discrimination. With that, I yield back.
Thank you. We'll now recognize Mr. Burleson for 5 minutes.
Thank you, Mr. Chairman. Mr. Susman, in your testimony, you noted that the GSU, the Graduate Student Union, they illegally threatened to terminate anyone who refused to pay for their activism. You filed a charge against the GSU with the NLRB regarding them violating your Beck rights. While the NLRB did agree that your rights had been violated, do you believe that they addressed the issue adequately?
No.
Can you elaborate?
Sure. They required that the union send out a PDF stating our rights, and then the union officers continued to do exactly the same thing that they had been doing all along.
So they just continued. They're not doing any enforcement whatsoever.
That's correct.
Have you noticed other examples of politically motivated activity within the GSU that they pushed on their members?
They spend all of their time protesting against Israel.
I'm sorry, I didn't hear that.
They spend all of their time protesting against Israel.
Okay. So they're spending so much time pushing against Israel. Did they take any steps whatsoever to protect the rights of their Jewish members?
No.
That you can recall?
Not that I can recall.
That's tragic. Mr. Tobman, in your testimony that you say that since October 7th and the attack on Israel, labor unions have become organizers of hateful anti-Jewish and anti-Israel propaganda and resolutions. From the discussions that you've had with workers, and it's tragic to hear that you're getting phone calls from all over the nation, have unions, I'll ask the same question, have you seen where unions have stepped in to take steps to protect their Jewish members who are being discriminated against at this time?
Never once, and I have taken calls from all over the country, universities, hospitals, legal aid. Not one employee has ever said to me, oh, the union has helped me, or, oh, I can go to the union and they'll help me. None.
Mr. Tobman, I hesitate to bring this up, but there has been, I know that in my state, for example, there have been lawsuits and complaints against labor unions, particularly, we have areas where there are high percentage of minorities, and yet the labor unions have a very low percentage of minorities in the single digits. And so there has been, there's often been a history, and I don't know if you have any comments about that. It's just the nature of this system to create that somehow emboldens discrimination within labor unions and the history of that.
Sure. I think the bottom line is the old adage, absolute power corrupts absolutely. If I can tell you, pay me or you're going to lose your job because I can get you fired, I would call that absolute dictatorial power in the workplace. And unions spend other people's money. Justice Scalia, in a Supreme Court case called Davenport, recognized that unions have a unique privilege in this country, the privilege of demanding other people's money, which they can then go use on all of these sorts of far-left, intersectional, woke politics, right? It's a lot more fun to go run around and riot on behalf of Hamas than it is to say, let's do a workplace grievance and see if we can get better wages in this place. Because that's boring, that's work. It's more fun to be, intersectional leftists.
Do you think the Beck decision was kind of a compromise rather than throw out? Because I think that the forced unionization is a violation of the First Amendment rights of association. So do you think that the Beck decision was a way to kind of split the baby and say you don't have to join, you don't have to be a member, but you still have to pay? And many of the examples are that you have to pay the exact same amount. And so the question is, do people truly have a right of an association?
Well, yes, and all of these decisions have been split the babies. If you go back to the original duty of fair representation decision, Steele versus Louisville and Nashville Railroad, where the unions were discriminating against black workers and refusing to let them join, The Supreme Court said, oh, we don't want to strike down the Railway Labor Act and these federal laws, so we'll create this thing called the duty of fair representation, and that'll fix the problem. Instead, they should have struck down these laws which violate people's free association rights. And we're going to continue to litigate to make that happen. And hopefully it'll happen in my lifetime.
Thank you for what you do, and I appreciate your comments. My time has expired.
Thank you.
Thank you. We'll now recognize Mr. Scott from Virginia for 5 minutes.
Thank you, Mr. Chairman. Dr. Lofaso, is it true that those who belong to unions generally get higher pay than non-union members?
Yes.
And do they get safer workplaces?
I'm sorry, I didn't hear the question.
Safer workplaces
Yes.
and better
I've actually written on that.
and better benefits?
Yes.
Now, in paying union dues, you said that they could opt out of paying the full dues and just pay for those that go to representational expenses. Is that right?
That's in fair share states. In right-to-work states, they don't have to pay any dues.
But they get all of the benefits of the union efforts.
That's correct. There's a duty of fair representation.
Okay. Now, if you're paying your fair share and not the full dues, do you have to pay for political activities?
No. No one has to pay for political activities.
How about the annual summer cookout?
No.
How about the end of the year holiday party?
No.
Just the representation of what the union is legally required for representation for benefits that they get.
That's correct. And if they don't do those things, they can be sued, which I know Mr. Tobman knows very well because that's what he does.
Now, in terms of your right to pay the lower dues, that's your Beck right. Is that right?
That's correct.
And you're required to give your notice to opt out of the union. Is there any effort to let people know that they can opt into the union?
No.
Is that stacked against workers?
In my opinion, yes.
Okay. Now, you've heard from the gentleman from Missouri the well-known fact that equal opportunity in unions is not always the case. If you find religious or racial discrimination in a union, what agency can you go to for relief?
The EEOC.
And what do you think of cutting funding for the EEOC if that's your goal?
It would be very difficult to enforce the rights of people.
For those of us who are interested in protecting workers' rights, what do you have to say about the law that allows employers to fire workers and often not have to pay anything?
I think that is selfish, actually, because it puts a burden on every other person to pay for their representation. If then that person is fired, the union still has to represent them, and that costs them money, and that individual does not have to pay the union anything.
For those that do not belong to the union, the union has to represent you the same as they would a union member?
Yes, otherwise it would be a breach of their duty of fair representation.
Does that mean that they have to, if it's an individualized grievance, not just a general grievance, but an individualized grievance, a non-union member has the right to the same representation as dues-paying union members in right-to-work states?
Yes, actually, the Supreme Court expressly said that in city disposal.
I've introduced a bill protecting the right to organize that says employers who fire workers who are for union activities can often escape without any sanctions. Is that true?
Yes.
What is a sanction for illegally firing a worker?
It would be back pay and reinstatement and minus mitigation.
Minus mitigation means if you left a non-union shop and got a good union job and made more than you were making before, there would be no sanction.
That would be correct.
Thank you, Mr. Chairman. I yield back.
Thank you. We'll now recognize Dr. Fox for 5 minutes.
Thank you, Mr. Chairman. Ms. Copar, you discussed in your testimony how the ALAA's pro-Palestine resolution impacted you and other dissenting union members. ALAA leadership later voted 124 to 18 against a resolution condemning Hamas and requesting the release of hostages. A paid union staffer said to all union membership that you sought to distract the union from its support for Palestine. What does the outcome of the leadership vote on releasing hostages say about those leading your union and the individuals they've hired to staff the union?
Thank you, Dr. Fox. By voting down the release by voting down that resolution to release the hostages in such an overwhelming matter and overwhelming numbers, the union showed its true face that the lives of Jews don't matter. They dehumanized the hostages, including American hostages, including hostages that came from New York, from Long Island. And by not recognizing that they were abducted violently and still being kept in Gaza, and they demonized us for showing our support of Israel. I mean, the things that were said in Gaggle and the Joint Council meeting at that night was so shocking to all of us, all of the Zionist members, because it showed the true face of the union on that night. They don't recognize that hostages are entitled to freedom and human rights. And the simple reason for that is because they're Jewish. And to us, to me, that's anti-Semitism in its most basic form.
Thank you very much. Mr. Tobman, for decades you've litigated cases to protect the rights of individual workers who want to limit their association with labor unions who they want no part of. After the October 7 attack on Israel, was there an increase in the number of calls to you from workers seeking to associate from the union?
Thank you for your leadership, Dr. Fox. The answer is that my phone has been ringing off the hook, and my colleagues' phones have been ringing off the hook from doctors, from teachers, from legal aid, from people all over the country wondering how they can get out of these horrible anti-Semitic unions.
So what were the Jewish union members experiencing at their workplaces?
The other people on the panel, like Mr. Susman, can tell you, because they're there on the front line. I can tell you anecdotally what I hear. Let me just read you from what some Jewish employees at CUNY, City University of New York, have said recently. Nails were found in their tires. Anti-Semitic flyers distributed all over the campus. Malicious and relentless campaigns to get them fired because they were Zionists. Discussions that observant Jews were undesirable for membership. Requests to remove observant Jewish faculty members. This is virtually Nazi-like from out of the 1930s. And that's what these people are seeing on their campuses.
Thank you very much. Mr. Susman, your written testimony notes that in April, the Graduate Student Union at MIT pushed through a ceasefire resolution that does not mention peace, hostages, or Hamas. The divisive resolution passed with very low voter participation. Did the union ever seek out the opinion of Jewish graduate students who they represent before pushing this resolution forward?
They did not, and some Jewish students attended the general membership meeting where they discussed the resolution and asked the committee members who did they discuss the resolution with, and they said they looked inside themselves.
Thank you very much. I want to thank our witnesses for being here today to shed additional light on the anti-Semitism that is occurring within unions and let the American people understand how deep, pervasive, and harmful this is to our Jewish citizens. Thank you, Mr. Chairman. I yield back.
Thank you. We'll now recognize Ms. Houchin from Indiana for 5 minutes.
Thank you, Mr. Chairman. Thank you to the ranking member. Thanks for being here to testify before us today. Really appreciated all of your opening statements. I've made very clear to this committee my stance on unionization, which has been heavily influenced by my own state's success as a right-to-work state, the state of Indiana. And I'm supportive of federal right-to-work legislation because I recognize that under current federal law, workers' individual liberties and their right to make decisions currently concerning unionization are poorly protected. In your testimony, Mr. Tobman, you mentioned how some American unions are now discriminating against and threatening Jewish workers, and that has been especially prevalent following the October 7th attacks on Israel. What legislative reforms do you suggest to Congress that we should consider to protect workers' rights with respect to unions?
Thank you for that fantastic question. Number one, certainly, is a national right-to-work law. This shouldn't be a state issue. This shouldn't even be a partisan issue. Nobody tells you you have to join a specific church or a specific group, or you have to pay money to a private organization. That doesn't happen anywhere else in American life except for the privileged labor unions that have been doing this since the 30s and the 40s. That's the first thing, pass a national right-to-work law. The second thing is, if you're not going to pass a national right-to-work law, there are things like recertification elections automatically. Every member in this room stands for an election automatically every 2 years, every senator every 6 years. Do you know how often unions automatically stand for re-election? The answer is zero. They never have to stand for re-election unless the employees can band together to throw them out. And in a place like MIT with thousands of grad students that rotate through for 1 or 2 or 3 years, that will never happen. Ronald Reagan said the closest thing to eternal life on earth is a government program. I can tell you the closest thing to eternal life on earth for these unions is to represent a bunch of graduate students.
Thank you. Dr. Lofaso, in your written testimony, you have a section about compelled union dues, and you note that under Beck, employees who work in right-to-work states can't be compelled to pay any dues or fees. I'm certainly glad that my state of Indiana is a right-to-work state so that people are not compelled to pay union dues or fees, even the cost of representation. However, you state that under Beck, employees who work in non-right-to-work states can only be required to pay their, quote, fair share of the cost of their representation. So my question to you is, what constitutes fair share for the cost of representation to an organization that is politically and ideologically opposed to some of their members' very being?
Well, under that question, they would not have to pay for any of those activities.
But they do have to pay for fees, is that correct?
They would, but they could also withdraw. They can withdraw by doing a Section 19 NLRB objection. So that means they would not have to pay any of those dues to the union.
It seems like, though, we've had some conflicting testimony to that today, that there are compelled fees that must be paid, and we will get to that. You also mentioned in your opening statement
that would be unlawful.
Sorry, I'm going to reclaim my time. You also mentioned in your opening statement that Congress and this committee should focus on real problems instead of what we're talking about today. Do you not believe that eradicating anti-Semitism from labor unions is a real problem?
I do, actually, but I don't think that that's the problem that is what's going on here. Because what we've heard today is that
But I'm going to reclaim my time. Would you not tell these other panelists, and you've heard their stories, that what they're dealing with is not a real problem? Would you concede that Mr. Susman's testimony constitutes a real problem? Yes or no? Because I've got only 46 seconds left.
I don't wish to give my personal opinion about anything.
So
here.
You're not going to answer whether you think that the testimony we've heard here today from the fellow panelists constitutes real problems. Thank you for that. Okay, I'm going to move on to Mr. Susman. Your written testimony notes that the union that represents you illegally threatened to terminate anyone who refused to pay for their activism. You filed charges against the GSU with the NLRB. The NLRB agreed that your rights had been violated. Did you think they adequately addressed the illegal union activity?
They did not adequately address it, no.
Thank you. I yield back.
Thank you. We'll now recognize the ranking member, Mr. DeSaulnier, for 5 minutes.
Thank you, Mr. Chairman. I live by the expression, I think a high school teacher told us that the only absolute you should deal with is the absolute you shouldn't deal with absolutes. And what we're dealing with here is very binary in both instances of the labor movement, my view, and anti-Semitism, but oftentimes, and it should be binary in the sense of the rules. You shouldn't be anti-Semitic, period. You should value workers and their employers in a balanced way. So, Doctor, you talked about this, and to the witnesses, particularly Ms. Copman and Mr. Susman, we probably disagree on a lot of things, but I agree that your minority rights should be protected. But they are minority rights. So when we lose elections, those of us who believe in democracy, unless there is a demonstrable legal analysis of unfairness, you accept the results. So in that context, Doctor, you mentioned this a little earlier. Could you go a little bit further of how the law is meant to protect minority rights, but also the rights of the majority through the electoral process and the union movement? And one other thing, there was a comment earlier about unions being historically not including equity. I'm from California. The California building trades is 85% minority and women. The Labor Federation is a little bit below that nationally. Women now a majority of the labor movement. And African Americans are at a higher proportion in a union and people of color than in non-union working places. Historically, we've changed over time on regional bases and other bases. But just for clarity, unions are very, very, very diverse right now, and that diversity is protected, not absolutely. So, Doctor, with those comments, would you care to speak on any of that, the protection of minority rights and the level of diversity in the union movement?
Yes. First of all, I feel my testimony was mischaracterized, that I do think anti-Semitism is a huge problem, but I just feel that I'm here to talk about labor law. I am not an expert in that type of thing, and therefore my opinion doesn't really matter about that. What really matters is what these people are experiencing, and they're saying, our great justice system they'll be able to go through it, and they will get remedies. Now, unfortunately, NLRA remedies are very weak, and therefore they can't get the remedies that they need. I think if the NLRB were funded, then they maybe could afford training or more staffing to get this through. In terms of minority rights, there are many things that, if a union discriminates against anyone, including Jews, any type of religion, any person of any race, then that would be against the law. That would be against Title VII, and then that would be investigated by that agency. They also could, and if they do that, so I think there's a difference between about people who are breaking the law and what the law is. Obviously, we have laws because people break laws. We don't regulate things that aren't a problem. So we have solutions here for minority rights, and that's important. What we don't have, and that's what I meant by the real problem, are workers' rights that are meaningful, that can enforce this. Obviously, anti-Semitism is absolutely wrong, just like all hate.
You have said that the majority party's Union Members' Right to Know Act is a solution in search of a problem, an example of overregulation. Would you expand on that?
Sure. We have already regulated this area. We have Ronald Coase, who is a great libertarian economist, said you only regulate when there's a market failure. So limited, he's often misstated as never regulations, but you only regulate when there's a market failure. Here, what we have is what the committee seems to be focusing on is the stuff that's already regulated and has remedies. Instead of what the real problem is, which is getting remedies for an unfair labor practice. Mr. Susman had an unfair labor practice problem. That's the real problem. And if a union actually will say that he had to join, if a union said that he had to join them, they were wrong and they violated the law and they should be prosecuted.
Thank you. I now recognize myself for 5 minutes. Mr. Tobman, I'm thankful to live in and represent Virginia, a right-to-work state, where employees thankfully cannot be forced to pay union dues. I certainly didn't choose to pay any union dues when I was working in a unionized auto factory during my college time. And God forbid that we should ever have realized into law the Democrats' dream of this PRO Act, which essentially says to every employer across the country, embrace a union or close your doors. 2 options that would result from that. But you've noted, as incredible as this is today, that under federal law, Jewish workers who live in non-right-to-work states, who suffer in non-right-to-work states, can be forced to pay union dues that pay dues to a union, that expresses hateful anti-Semitic rhetoric or views. And you noted, but I'll just ask you again, can you say any other aspect of American life where an individual is forced to fund a private entity that expresses speech that they find hateful, threatening, or objectionable?
Thankfully, I know of no other example.
Let's hope that this becomes the isolated example that we have to fight versus some occurring more broadly in our society. Ms. Copar, it seems that the terribly offensive ceasefire resolution that you've described, that was 3 days after the October 7 brutal attack, never mentions the Hamas terrorists and was ultimately adopted by the union. But that was really a continuation, wasn't it, and an escalation of the union having allowed anti-Semitism to fester under the surface for months, wasn't it?
Yes, that is
true. Can you talk about that, how it had been allowed just to continue prior to that resolution?
Yes, actually prior to the ALAA's resolution, there were 2 additional resolutions that had been introduced by other ALAA chapters, namely the Bronx Defenders as well as CAMDA chapters. Those particular resolutions were also very anti-Semitic. The Bronx Defenders resolution actually was advocating, or at least it advocated for the Hamas violence against Israel. And so there was this hostile work environment that had already been fomented by these other chapters. There had been inter-office emails that were at legal aid in the city where people were questioning whether or not Jewish attorneys can actually represent our clients. And so there had been this sort of like this turmoil that had been going on that fomented itself with this resolution that was introduced in November.
Yeah, you referenced in your testimony verbally and your written testimony about some of these terrible, hateful, offensive messaging through the gaggle, the internal message board of ALA. Things, as you referenced, and you said that we were called fascists, genociders, genocide deniers, snitches, and Zionist goals. We were told to go kill ourselves. The slogan "From the river to the sea" was routinely used, and so forth. In light of this, did ALAA leadership ever intervene or condemn these messages, or even call for some semblance of civility in the face of what the Jewish members, who they purport to represent, were having to suffer through?
Never. They never stopped the bullying. They never called anyone out to stop the bullying and to stop the vitriol. And in fact, they doubled down by after that one joint council meeting that we had where we introduced the release the hostage resolution. That very next day, a paid ALA staffer actually blamed the Zionist minority for all of the issues that it was having. They blamed us. And so they actually have been promoting this. They've actually been dividing the membership. They've been fostering the hostile work environment. So no, they've done nothing to tamp it down, and it's only been getting worse.
Everyone should be concerned about the unique, horrific situation in the world and in the country today, where when Israel can be horrifically attacked, is blamed for an attack, and when Jews are discriminated against, harassed, intimidated, threatened, and harmed, Jews are blamed for that. That is unique, and it should be condemned unequivocally across the country, and everyone should be concerned about that. With that, I would like to recognize the ranking member for his closing remarks.
Thank you, Mr. Chairman. And I would agree with your overall sentiment, but I found it frustrating as a longtime supporter of Israel's right to exist, having a very good relationship with the Jewish community in the San Francisco Bay Area and California for 35 years. I've been elected office, but also being a pro-union in this instance. Pro-democracy. And one of the reasons I support Israel's right to exist is a democracy. But within that, just like in America, that doesn't mean I agree with the current, or at any particular time, administration. I disagree with the policies after October 7th of the current administration in Israel. That doesn't make me anti-Semitic. That makes me a believer in democracy. And we get in trouble in democracies, just my observation in history, when we start assuming that if you disagree with the majority party of any democracy, that you are inherently against their God, or you have the moral authority. So, and we all have to reflect on that, because I think liberals do it, conservatives do it, we just have to reflect in proportion. In relationship to what the testimony we've had here today, Mr. Chairman, I'd be delighted to talk to you about how we can further minority rights to make sure they're protected, because I think it does a tremendous disservice, and your testimony here adds a disservice to the majority of people who are in the labor movement, who I would hope very strongly would not do what you have described was your example. So I make that an offer. Be happy to meet with you as well to see if I can help make sure that the disincentives are there to protect minority rights. Combating anti-Semitism and other forms of hate transcends political divisions. I'm being a little bit repetitive here. It's a moral imperative that demands our unwavering commitment. We must ensure our workplaces are not only safe, but also inclusive, fostering environments where every individual, regardless of their background, can thrive and contribute fully. This hearing also importantly highlighted the many ways that law provides recourse for workers who feel they may have been mistreated by unions. And as I said, I'd be willing to work on remedies if that's not the case, including funding agencies and disincentives for people who do violate the law, as well as the shortfalls of our current law when it comes to informing workers of their right to organize with their coworkers free of employer coercion. I extend my sincere appreciation to the witnesses, experts, and advocates whose contributions have enriched today's discussion. Thank you all for being here and taking the time to prepare for this hearing over the July 4th holiday week. Moving forward, we must strengthen our support of initiatives, in my view, like the PRO Act, that bolster protections for workers and uphold their rights in the workplace. By doing so, we can build an economy that prioritizes fairness and opportunity for all. And I yield back.
Thank you. I now recognize myself for closing remarks. I want to apologize to the Jewish Americans here today and across the country for the necessity of having this hearing. The concerns here today have been specifically directed towards union bosses and union leadership across the country. Again, how have we gotten to the point where this hearing is necessary, but it's demonstrated by the content of what's been discussed here today and by the testimony of our witnesses and what they've experienced. And while this might be a difficult topic, I'm glad today's hearing could shine a light on the continued problems of anti-Semitism in this country, much of which is unique to our Jewish friends, including, again, among the leadership of our nation's labor unions. For some reason, many union leaders would rather double down on defending a terrorist organization than focus on local workers' issues. They would rather sow division than unite workers around areas of common interest, and they're willing to abandon pro-Israel Jewish employees who then have to face coercion or retaliation as they fight themselves for their rights. It reinforces my belief that unions have long outlived their usefulness. I'll say it again. Unions have long outlived their usefulness in this country. As always, it's worth noting and repeating that thankfully, private sector unionization is at the lowest level ever recorded in America, at 6%. The first part of a union should be protecting the rights of its members, and unions that fail to do so should be held accountable. This committee will continue to examine ways to strengthen current law to protect union members from abuses and misguided pursuits. So again, I thank our witnesses for taking time today to share your stories and your insights and your experiences today. Without objection, there being no further business, this committee stands adjourned.